Welcome to Cease and Desist. In our final conversation of the year, our SVP of Client Relations, Joanna Summers, sits down with Stefan Cassella. He has authored over 50 law review articles and played a pivotal role in shaping and advancing federal asset forfeiture laws in the US and abroad. Today, as the founder of Asset Forfeiture Law, he continues to provide invaluable guidance to law enforcement, private law firms, and financial institutions by providing expert witness services, training, and legal guidance. In this episode, Joanna and Stef explore the growing role of cryptocurrency in criminal investigations and asset forfeiture, highlighting its use in crimes like money laundering, investment fraud, and sanctions evasion. Together, Joanna and Stefan unpack the complexities of high-profile cases like Bitcoin fog, the legal challenges posed by mixers and decentralized exchanges, and the significance of recent court decisions in legitimizing blockchain analytics tools. Stefan also shares practical advice for law enforcement and attorneys navigating the crypto landscape, highlighting the need for enhanced training and resources to address these evolving threats, and the critical role of non-conviction-based asset forfeiture, or civil asset forfeiture, as a key law enforcement tool. Let's get into the conversation.
Steph, I can't think of anyone more appropriate to discuss the legal landscape of asset forfeiture with and what an essential tool forfeiture is for law enforcement. Before we dive into today's episode and some questions, Steph, you were a federal prosecutor for the Department of Justice for 30 years. At one point, you and I overlapped at DOJ. I know you specialized in money laundering and asset forfeiture while you were there. You've also written over 50 law review articles on these topics, and you've been instrumental in the use of federal asset forfeiture laws. Can you tell us a little bit more about your experience at DOJ and then more recently starting your own consulting company when you retired?
Well, yes, thank you so much, Joanna, for having me. It's great to be with you. I was at DOJ for 30 years, and for most of that time, money laundering and forfeiture were my areas. I did training. I tried multiple cases, some of them high profile. I drafted legislation, and I had a supervisory responsibility for policy development, all of which was interesting because those were cutting areas of the law that were just emerging. A lot of it, we were making it up as we went along, and a lot of what we do today in federal law enforcement is based on what we developed in the 1990s and early 2000s. Since then, I've been working as a consultant. I consult with federal law enforcement agencies. I consult with private law firms. Anyone who would like to have some better understanding of what forfeiture is or what money laundering is, a lot of it is done overseas. And I do that to help countries that want to develop their capacity in forfeiture and in the recovery of assets and in prosecuting money laundering cases.
Well, we love to hear that. I'll dive into the questions today. Asset forfeiture has long been a powerful tool in combating various types of crime, from drug trafficking and counterterrorism to complex fraud schemes. Are we now seeing that cryptocurrency is following a similar pattern where it's a significant asset in a wide range of forfeiture cases? I mean, you've seen it all over the years.
That's exactly right. One of the things that I do in my current business is to publish a monthly digest of asset forfeiture and money laundering cases. That is summaries of all the cases decided by the courts in the previous month. And I've been seeing a tremendous number of cases in which cryptocurrency is a factor, is maybe the major factor. And so I did a deep dive into that, and I looked back 5 years, and it turns out there are more than 50 reported cases in which cryptocurrencies are a major factor. And they have a wide variety. I mean, some of them are old wine in new bottles. I mean, there's not a whole lot difference when it comes to investment fraud between convincing someone to invest in a non-existent cryptocurrency and trying to get him to invest in a non-existent gold mine or non-existent oil well. And so there's some of that, but there are also many new schemes or ways in which old crimes are being committed in totally new ways because of the advent of crypto. Money laundering is a good example. Commingling funds from an illicit source with funds from a legitimate source was always a way of committing money laundering. It helps to conceal or disguise the illicit assets. But now we have these tumbling operations like Bitcoin fog and Helix and others, where you've raised that to a new level, merging, commingling cryptocurrency derived from a crime with cryptocurrency that other people are investing and making it impossible to trace the money. So those are two of the ways in which we're seeing crypto, and I could give you some other examples if you'd like.
Please do give us some other examples. I love the analogy of old wine in a new bottle because I think that really fits.
Well, sure. You have cases where people wanted to engage in the purchase of contraband child pornography or drugs, and they use cryptocurrency to do it because they think that that gives them some level of anonymity. You have extortion cases. People are trying to blackmail, or they've shut down your business and they want you to pay a ransom, and they ask for the ransom to be paid in crypto, called ransomware, because it's more difficult for law enforcement then to figure out who is receiving the money and therefore who committed the extortion. There are people who are evading sanctions on countries such as North Korea and Iran, where they transfer the money in crypto because it's more difficult to determine that the money is being held by a sanctioned person or that it's going to a sanctioned country. You have people who are being defrauded in crypto. You get a phone call. Hey, your bank account has been compromised. You need to secure it by transferring the money to this crypto wallet, this Bitcoin wallet. And people do that, and they find that they've, of course, transferred their money to the bad guy. Or you have people committing embezzlement, where they get the bank to transfer their employer's money in crypto out of the bank account. And then finally, you have people actually stealing crypto from each other. They get each other's personal keys, and they go into wallets, and they transfer the money, and they steal it. There was a very famous case involving hundreds of millions of dollars stolen by North Korean operatives who got private keys and transferred the money to the North Korean nuclear weapons program. So you see all of that. And what's important to understand is that these are a mix of criminal cases, criminal prosecutions for money laundering and the underlying fraud or embezzlement or whatever it might be, and civil forfeiture cases, because civil forfeiture turns out to be, for good reason, essential in being able to recover the money for the benefit of the victims and to make sure that the bad guys don't get to keep it.
Absolutely. I read a really interesting survey from TRM. It was a 2023 survey of law enforcement that found 60% of crypto investigations started off without an obvious crypto component, which says to me everything that you just said is completely spot on, that in the future, the vast majority of cases will include cryptocurrency, and there's just so many different types of cases that they could be. And I want to come back to a point you just made on civil forfeiture. Let's talk a little bit about why civil asset forfeiture is such an important tool for all of the categories you just discussed. Can you explain what civil asset forfeiture is, or non-conviction based forfeiture, and why in particular it's so important for cryptocurrency?
Sure, absolutely. The term the rest of the world uses is non-conviction-based forfeiture, and that sort of tells you what the essence of it is. You still have to prove, if you're the government, you still have to prove that a crime was committed, and you have to prove the connection between the property and the crime. But you're not trying to put someone in jail. You're not trying to obtain a criminal conviction of someone. You're trying instead to recover the property. So the focus is not on who the bad guy is and what he did and how he should be punished. The focus is on where did this money come from, and should it be recovered because it was involved in or derived from a crime. So the government still has to prove a crime, and it still has to prove the property is connected to the crime, but it doesn't have to have the bad guy in hand, because again, you're not trying to punish him, you're trying to take the property. That's why the cases have funny names. The United States of America versus 153 virtual currency accounts, or something of that nature. It's not that the property did something wrong, or that the property has to hire a lawyer to defend itself in court. It's that the government is able to establish that a crime was committed, and that this is the property involved in the crime, and this is the property the government wants to recover, and anybody who wants to contest that has the right to intervene and put the government to its proof. Now, why is it essential in these cases? Because you don't need to have identified the wrongdoer. You may have clear evidence that this property was stolen by someone operating from overseas, an obvious fraud, it's an obvious theft, but you don't know who the bad guy overseas is. Or even if you do know who he is, you don't have him within your jurisdiction to prosecute him. He may be somebody in Russia. He may be someone in China. He may be someone in an African country. And you just don't know how you would ever obtain a conviction of him or her, or how you would get the money recovered as part of the criminal sentence without being able to get that person in your jurisdiction. But you have the money. The money is in a crypto wallet in the United States, or the money is being held by a cryptocurrency exchange like Coinbase, or the money is in an account in another country that will honor and enforce an American forfeiture order. So as long as you can establish the property was derived from a crime, and you can prove the crime, and you know where the property is, you go after the property and you recover it, make sure the bad guys don't get to keep it, and make sure that if there are victims, it can be restored to victims. So there are a lot of examples of that, cases where law enforcement has traced the money stolen in a fraud scheme to a crypto wallet at a cryptocurrency exchange at Binance or Coinbase or someplace, and they just bring a civil action against that property, invite anybody who wants to contest it to do so. Often no one does, and then recover the money.
I think the need for speed in cryptocurrency is so important. We know the funds can move at the click of a button, and that's really helpful to have civil forfeiture. Otherwise, we really wouldn't have very many crypto asset recoveries. And as you mentioned, so many of these cases are victims' cases. The first question victims always ask is, how do I get my money back? So I think a lot of the time we focus on, we really want to get the bad guy and lock him up, but really the victims would prefer to see their funds back before anything else happened. I agree, it's a really powerful tool, and that was a great summary of what civil asset forfeiture can do.
I don't think most laypersons understand that the vast majority of civil forfeiture cases that the government brings are brought for the purpose of recovering money for victims. If you have a victim in a case, the first priority of the government once it recovers the money is to use it to reimburse the victims. It's only in the victimless crimes like drug trafficking where the government ends up holding onto the money.
Absolutely. So thinking about some of the issues we face in the United States, we know there's a lot of regulatory gaps in crypto in the US. And with Trump coming into his second presidency in 2025, do you think we'll see any of those gaps filled? Do you think the regulatory gaps that we have right now are making crypto difficult for law enforcement? Is poor regulation a factor in some state or local or even going up to federal agencies having difficulty working these cases?
Well, I think all of that is true. The lack of regulation and the lack of expertise within law enforcement are both considerable problems. Crypto is attractive because it's the shiny new object, right? It's the bright new ornament on the Christmas tree. So if you're looking to get rich quick and you want to invest in something that seems to be going up every day, you invest in crypto. If you're looking for anonymity, you think it's anonymous to purchase your child pornography using crypto, then you do that. But it's a technology that people know very little about, over which there's virtually very little regulatory oversight, and that leads to problems. So I call it an ephemeral asset that is marked by complexity that few understand and a vocabulary that few have mastered. And those are the things that make victims vulnerable when crypto is involved, but they're also the same things that create challenges for law enforcement. Law enforcement agents have as much trouble wrapping their minds around the concept of what is a crypto asset and learning the vocabulary as anyone else does. There are experts. You and I both know who they are. They're not very many. They're very, very good, but they're very few. What we need to have all of law enforcement, because these cases, as we started off talking about, are showing up everywhere and in every context. We need all of law enforcement to have training, to have access to advanced technology. They need to know what a crypto asset is. They need to know how to trace it, to find out where it is and where it came from. And they need to know how to seize it. How do you take that into possession of law enforcement? The lack of regulatory oversight makes these crimes easier to commit and harder to detect. That's certainly the case, and I fear that it's likely to be a situation that's going to get worse rather than better if the president-elect is serious about reducing the already lax regulation of the crypto industry. And there's one other thing about crypto that's really problematic for law enforcement, and that are sovereignty issues. We in law enforcement are still working under sort of 19th century concepts of operating within the sovereign borders of our countries. The advent of online banking made that a problem because bad guys could easily move the money between jurisdictions, across borders, much more quickly than law enforcement could exercise law enforcement powers across borders because of rules relating to sovereignty and jurisdiction. While crypto operates in a world where there are no borders, never mind across borders, there are no borders. Where is the crypto? Where is it located? Is it in your country or in my country? And those create jurisdictional problems for law enforcement in almost every case.
Those are really great points. And you mentioned that a lot of people don't understand the complexity. If you understand the vocabulary, it's still an uphill battle. And even though I'm still a little mad at John Oliver for his hit piece on civil forfeiture a few years back, he has a really good quote that says, "Bitcoin is everything people don't know about computers combined with everything they don't understand about money."
That's very good.
I think it's really fitting. And to your point on training too, I think this is why we've had such a focus at Asset Reality on training as well. We've just developed our virtual asset transfer fundamentals course. We want to make sure everyone understands how to do transfers, how to seize cryptocurrency, how to custody it. So I think training and resources go a long way in making sure that everyone can work these types of cases. Let's get into some specific cases. We've talked about how crypto has reinvented traditional crimes like money laundering by introducing more complex ways to obscure the source of funds. While laundering itself isn't new, you've got Helix, Bitcoin Fog, and other mixers that have allowed criminals to take these schemes to a new level of sophistication. Recently, the operator of Bitcoin Fog was sentenced to 12 and a half years in prison. He was ordered to forfeit approximately $500 million. We're incredibly proud at Asset Reality to say two of the agents who worked on that case are now part of the team at Asset Reality too. How do cases involving technologies like mixers and decentralized exchanges, how do they complicate the asset forfeiture process? Were there any notable aspects of how the court approached these arguments in Bitcoin Fog, like what could be forfeited?
Well, yeah, there are two really interesting aspects to the Bitcoin Fog case in the context in which we are speaking. One is, as I mentioned before, in a civil forfeiture case, and in some criminal forfeiture cases as well, you have to be able to trace the money you want to recover back to the crime. In a civil forfeiture case, you have to do that in order to establish that this money is the thing that was involved in the criminal offense. In a money laundering case, you need to do that because there's no money laundering crime unless the property that the subject matter of the transaction is criminal proceeds. So in both contexts, you need to be able to establish that these bits and bytes on a computer that represent someone's assets in a Bitcoin wallet or some other cryptocurrency, Tether or whatever it might be, are traceable back to a crime. And how do you do that? And it turns out that the bad guys think that it's impossible to do that, and that's why they use crypto, because everything moves in what appears to be an anonymous setting. But our colleagues in the private sector who have developed these software packages, such as in the case of Bitcoin Fog, it was chain analysis and their reactor program, they have sophisticated software which can analyze the blockchain. The umbrella term is the blockchain, but there are many variations on that. But it actually looks at all of the transactions on this publicly available register of all cryptocurrency transactions, and it can look for patterns, and it can establish, for example, that if the same person is accessing multiple crypto assets, then the same person must be the owner of those because he has to be the one who has the private keys to all of those assets. Or if multiple transactions are being conducted in the same manner, then there's a presumption that those are being conducted by the same person. And so what they had developed through this software was a law enforcement tool that establishes to some degree of certainty that the particular assets in question belong to this particular person and were derived from this particular event, which would have been a criminal offense. Now, in the Bitcoin case, the government wanted to introduce that evidence, those findings, that the results of the use of that software, into evidence. And the defense said, well, this is junk science. This is not something that anybody could rely on to establish that this is correct. Sort of like in the early days of fingerprints. If a law enforcement officer came in and said, I've matched the fingerprints on the firearm, the murder weapon, to this guy's fingerprints, that should be admissible into evidence because that establishes that he's the guy. Someone at the time might have said, but that's junk science. There's no reason to believe that fingerprints are unique and that they're reliable. And ultimately, the courts decided that they were unique and they were reliable. Well, that's what's happening now with respect to this blockchain analysis. In the Bitcoin Fog case, the court held what's called a Daubert hearing, a hearing on the reliability of scientific evidence, and decided that this blockchain analysis that they used in that case was reliable, that it was scientifically valid, that it was a way of determining the source of and the ownership of the cryptocurrency. And so it was found in that case that it was admissible into evidence. Now, the defendant was entitled to object to that, to argue that it was not reliable, to cross-examine the witnesses, but nevertheless, the point was that it was admissible and it was going to be given to the jury, and the jury could then decide whether it was admissible. In these cases we're talking about are tumbling cases where the assets of many people are commingled in various ways, and they hop from one crypto wallet to another and so forth in a way that's supposed to make it impossible to tell which assets are licit and which ones are illicit, or to trace them to a particular owner. But these technologies are making that possible. The bottom line being, crypto is not as anonymous as the bad guys believe. It really can be traced. And in fact, sometimes it's actually easier to establish the tracing in a crypto case if you can do the technical analysis that we're talking about than if they were going through bank accounts, because if you go through bank accounts in jurisdictions like the British Virgin Islands or the Cayman Islands, or places where the government has no access to the records because of bank secrecy rules, you have less information than you do when it's on a blockchain analysis, because that's all public. So ironically, there are ways in which this technology is making it easier for law enforcement to trace the assets and connect them to the bad guy.
Yeah, and you bring up a great point on the Sterlingov case. It highlighted that scope of money laundering facilitated by cryptocurrency and mixers, but it did also bring attention to the tools that were used to investigate the crimes. During the Daubert hearing, Chainalysis's reactor license was deemed admissible and credible as evidence. And I know that that's been a huge point. It's something that we're actually going to touch on in an upcoming episode as well. We'll do a deep dive on that and why it was not considered junk science. But in your opinion, how significant is this decision for the future of crypto investigations, and what does it mean for the legitimacy of blockchain analysis tools in court?
Well, I think it's incredibly important because now we have a tool that not only is alerting law enforcement to the connection between the particular property and the illicit source and the particular owner, but that it's going to be something that jurors can consider. And taken together with other decisions in similar cases besides Bitcoin Fog case, which is the Sterlingov case, this means that there'll be more money laundering convictions. That means there'll be the recovery of more assets through criminal and civil forfeiture. So it's one of the most significant developments that's come along so far. The other major legal decision that was made in the Bitcoin Fog case had to do with what is forfeitable. We talked a bit about the technology that was used to prove the case, but then at the end of the day, once you've proven the case, what does the bad guy have to forfeit? In a money laundering case, the law is that the defendant has to forfeit all property involved in the offense. Not just the illegal proceeds being laundered, but all property involved in the offense. So if he commingled $1 million in illicit cryptocurrency with $3 million in other funds to conceal or disguise it, he has to forfeit the entire $4 million. That's straightforward money laundering forfeiture law. How does it apply in this case? Well, he's a money launderer who didn't own the money. He was laundering it on behalf of third parties. He took somebody's dirty money and combined it with somebody else's clean money and tumbled it around so that as to conceal or disguise the dirty money, and then he returned it all minus his fee to the original owners. Some of the original owners were bad guys, some of the original owners were not. But in doing this, he commingled almost $500 million. His argument was, yeah, but I didn't keep it. I gave it back to these other people. And the holding that's so significant in this case is that doesn't matter. You're liable for it anyway because you're the money launderer. And the money launderer has to pay a judgment equal to the amount of money that he laundered, the dirty money and the commingled clean money, even if he didn't keep it but gave it to his client minus his fee. And so that's why he ended up liable for this enormous sum of money, even though what his fee was a much smaller amount. He also argued that he should get credit for the amount that the government was able to recover from some of his clients. He said, but the government would recover twice if I have to pay after the client paid. And the court said, no. The purpose of forfeiture is not to make the government whole. This is not a double counting situation. The purpose of forfeiture is to punish. And there's no punishment to you if you get a get out of jail free card because the government recovered the money from your client. No, you're both going to pay. The client is going to forfeit the illicit money that he got back, and you're going to forfeit the amount of money that was involved in your money laundering offense. And that's what the holding was in Sterlingov.
Yeah, that's a great point, that the defendant gets no credit for what was returned, and the point is to punish. And I think it's really interesting that this was the first case to uphold all of this in the context of cryptocurrency. So really interesting case for sure. You are such a wealth of knowledge on so many different cases. I have to ask, what advice would you give attorneys or law enforcement agents that are new to handling crypto asset forfeiture cases? What are your pro tips?
Well, they need training. They need to understand the vocabulary. I mean, when you're in a conference and you say, well, the money moved into a Bitcoin wallet and then no one had access to the private key, I mean, eyes glaze over. And you say, well, think bank account when you think wallet, think password when you think private key. Everyone goes, oh, is that what you're talking about? So you need the training. You need to understand the vocabulary. You need to be familiar with the wide variety of cases or schemes in which crypto has become a factor. And they need to understand civil forfeiture and how it works, because that's the essential tool in so many of these cases.
And can you tell us a little bit more about your money laundering and forfeiture digest? How long have you been publishing it? Where can we sign up? I assume that the December edition includes the recent decision on Sterlingov?
Yeah, as a matter of fact, it does. We lead this month with the Sterling Gov decision and explaining what I was just saying earlier about the scope of what's forfeitable in a money laundering case involving tumbling crypto. I started doing a summary of forfeiture and money laundering cases for the Department of Justice when I was still employed there, and I continued that into the private sector. Publish a monthly digest. It's available on assetforfeiturelaw.us by subscription. About 3/4 of the U.S. Attorney's offices subscribe. Almost all the federal law enforcement agencies do, and a lot of private law firms, particularly the private law firms to which a former prosecutor has migrated when he or she left government. When they leave government and go to the private sector, they say, hey, I need to get the digest, and they get the firm to subscribe to it. It's not just a summary, it's also access to all of the cases that I've collected basically since 1993, believe it or not. So we have that many years of 30 years plus of collecting cases organized topically. So every month we summarize the cases from the previous month decided by the federal courts. And this month we lead with the Sterling Gov case, talking about what's forfeitable in a money laundering case. But we also have many other cases involving procedural issues that arise in forfeiture and interesting facts involving money laundering. So we're glad that people still find it useful.
That's incredible. What a summary of cases to have that much history. And what an awesome research tool for anyone who's just coming into this field, too.
I guess I shouldn't admit this, but I don't get on Westlaw anymore to do research. I know that all the forfeiture and money laundering cases are in those compilations. So I don't have to go find another one. I know if it's not in the compilation, then it doesn't exist. So that's my shorthand. I save a lot of research time and a lot of money not going on Westlaw because I know I've already got it.
That's awesome. Last question for you, Steph. If you could wave a magic wand and instantly resolve one challenge in this space, what would it be?
Well, I think that every country that has a cryptocurrency problem, which is every country, needs to enact civil or non-conviction-based forfeiture, and they need to train their people. They need to train their judges, their prosecutors, and their law enforcement agents, their police, in how to use them, because we are increasingly going to find that these crimes are being committed by people we can't identify or who are living in the functional equivalent of the couch in their mother's basement someplace in some faraway place, and we're not going to get our hands on them, but we're going to be able to recover the money through civil or non-conviction-based forfeiture. And so a lot of my time these days is spent helping other countries develop that capacity, and that's what I think they all are going to have to do to get their arms wrapped around this problem.
I think that's a really great point. And one of the problems I see in a lot of countries is even if they do have a non-conviction-based forfeiture option, they either haven't used it before or they're a little leery to do so. I think sometimes it's getting over that hump to do the first case and just get it in the books and get going, so you've got a process and you document it, and just knowing that it's an option. Having that is a huge solid approach. And also FATF has released best practices on confiscation and a framework for ongoing asset recovery, in particular recommendations 4 and 38, really focusing on the fact that countries should have this civil forfeiture, non-conviction-based forfeiture set up.
Yeah, that's right. I mean, the English common law countries, the United States, Canada, Britain, Australia, South Africa, have had non-conviction-based forfeiture for a long time and use it effectively. It's a strange new animal in a lot of the rest of the world, in the civil jurisdictions, mostly in Europe and elsewhere. And as more and more countries adopt it, it's recently been adopted in Argentina. I helped to draft the statute in Malta. There are ongoing discussions in the Baltic countries in Eastern Europe, some of which already have enacted it. All of that is to the good. But then, of course, putting it on the books isn't the end of the day. It's the beginning. It's the sunrise, not the sunset. You need to be able to get people to be comfortable using it. And judges are going to be skeptical. Judges are typically conservative people, not politically conservative, but judicially conservative. They don't want to do something new that departs from precedent unless they are convinced that it's fair and that all aspects of due process are being observed. And if you properly draft the statute and use it properly, then that's not a concern, but you need to convince everyone that's the case. And so all of that has to happen, and it has to happen Now, in the FATF's recommendation or now requirement that all countries include non-conviction-based confiscation, I think is extremely helpful and is going to push this forward.
I think so too, and I know you've done an incredible amount of work in other countries helping them develop that framework for this. And there are just so many considerations to it. It's not just the court piece, right? It's bringing the case forward. It's setting up a seized asset deposit fund or an asset forfeiture fund, and it's really drafting all the documentation that goes along with that and all the processes. So it's a heavy lift, but I think it's really worth it. And I think that there's so many cases that we can point to around the world that show how helpful it's been to have that in place.
Well, you're absolutely right on that last point about asset management. I was privileged to attend a seminar in Vancouver, British Columbia last summer in July, and I met with the people in British Columbia who do civil forfeiture. And they're doing great work, and they've got great cases, but they hadn't had a crypto case yet because they didn't know how you seize the crypto assets. And they said, how do you folks in the United States do this? That's fundamental. I mean, you can't start a case if you can't seize the property. And if they haven't learned what the process is by which you take possession of money in a crypto wallet, then you can't get these cases started. So that was one example of where, even in a very sophisticated country where they have the resources and where they have the expertise and the political will to do this, they still needed some assistance in figuring out how you take possession of the assets.
Training is really key in all of this, isn't it? Because if you don't even know what to look for, how to seize it, or how to transfer it, you're just not going to get anywhere. So I think that that's a really important point. And I think, learning is ongoing. It's not the type of thing you just do it once and you're good to go forever. I think, especially in the world of crypto, things change pretty frequently, and it's something you need to be working in fairly frequently to stay up to date with it. So I think annual training is really important when it comes to that. And I agree with you. We hear this in a lot of countries, either like, oh, we don't have cryptocurrency here, or we don't have any of those cases. And we know that they do. It's just a matter of where to look to find it. And if you don't know where to look, you think you don't have it.
That's right.
Steph, thank you so much for joining us today. This has been so informative, and we've loved having you on the show. We so appreciate your time today.
Well, it's been a pleasure to be with you. Would love to do this again sometime if I could be helpful. So best of luck with what you do. It's all important work. It'll be great to see how this develops in the years to come.
Absolutely. Thank you, Steph.
Bye-bye.
Thank you to Stef for sharing his valuable perspective with us today. If you've enjoyed today's conversation, like and subscribe to the Cease and Desist podcast on your preferred platform. Leave a comment and any suggestions for guests you'd like to hear from in the future. Next time, we look back at the 2024 highlights of the Cease and Desist podcast, exploring how asset seizures deter crime and the impact of returning forfeited funds to victims. Cease and Desist is brought to you by Asset Reality. Thank you for listening.
Our podcasts are for informational purposes only. They are not intended to provide legal, tax, financial, and/or investment advice. Listeners must consult their own advisors before making any decisions on the topics being discussed.